Hello friends, welcome to the session on conditions and warranties. In today's session, we will be studying and discussing conditions, warranties, types of conditions and warranties, etc. So let us begin. Let me ask you, what is a condition? In a contract of sale, parties make certain stipulations, that is provisions. They agree to certain terms regarding the quality of the goods, the price, the mode of its payment, the delivery of goods and its time and place. Thus, such stipulations which are very essential for the performance of the contract of sale are called as conditions. These stipulations are so important that non-performance of them may amount to breach of contract. It means contract will be termed as void. Obviously, the next question is, what is warranty? Warranty is a subsidiary part of the contract. The stipulations which are not so important are called as warranty. Its breach can only lead to a claim for damages, but not for repudiation of the contract. So, contract exists, but the defaulter party will have to pay the damages. Friends, there are two types of conditions and warranties, that is express condition and warranty, implied condition and warranty. Let us understand these two types. Express conditions and warranties are those conditions and warranties which are explicitly mentioned as terms of contract while entering into a contract of sale. The parties are free to decide their own terms on the quality of goods. Let us have a look on the example of a express condition. A buyer enter into a contract of sale. A seller mentioned the condition related to the payment, that is 80% of the amount should have been paid in advance and balance 20% at the time of delivery. On fulfillment of this, the contract of sale would take place. Or let us say the another example, two parties X and Y enter into a contract in Pune. Y, being a buyer, demanded delivery of goods in Mumbai. Then it will be termed as express condition of the contract of sale. Now we will take an example of express warranty. A typical example of express warranty is a warranty card issued by the seller. Warranty card which express that this equipment will be warranted for a period of 12 months for any manufacturing defects. If this has been mentioned on a warranty card, it will be termed as express warranty. Even we can consider the example of extended warranty. Say warranty period for a AC is 3 years, but buyer pays extra charges for next 2 years and get the extended warranty for another 2 years, which is expressly written on the warranty card. Implied conditions and warranties. Apart from the express condition and warranty, there are certain implied conditions and warranties which the seller should fulfill to protect the interest of the buyer. Let us have a look on this example of implied condition. A new brand car on the second day of its delivery develops a problem with the air conditioner. AC was not functioning. A problem can easily be fixed by filling up the gas required for AC. But technically the car is not of a merchantable quality. The buyer would be justified in returning the car and claim the damages. Let us have the example of implied warranty. The manufacturer has implied warranty to provide quality goods. Now friends, after understanding the basic types of conditions and warranty, let us understand the various implied conditions and implied warranties. In all, there are 8 implied conditions which seller must fulfill. Let us have a look on implied conditions. First, condition as to the title as per section 14A. Second, sale by description as per section 15. The third condition, implied condition in the case of sale by sample as well as description. This is a further extension of section 15. The fourth condition, as to the quality or fitness for a buyer's purpose as per section 16 subsection 1. Fifth condition, as to the merchantable quality as per section 16 subsection 2. Sixth condition, as to the sale by custom as per section 16 subsection 3. Seventh condition in the case of the sale by sample as per section 17, and the last condition as to the wholesomeness. Now, we will see implied warranties. There are 4 implied warranties. First one, implied warranty of quiet possession. The second one, implied warranty of freedom from encumbrances. The third one, implied warranty as to the quality or fitness by usage of the trade. And the last one, implied warranty to disclose the dangerous nature of the goods. So, let us have a look on these conditions one by one. The first one, implied condition as to title as per section 14a. It is an implied condition on the part of the seller that in case of sale, he has right to sell. In case of an agreement to sell, he will have right to sell at the time when property is to pass. For example, Amit bought the car from Rajiv and used it for 4 months. Rajiv did not possess the good title of the car, and at the end of the 4th month, the true owner of the car came and demanded the car. Amit did not have any option than handing it over to the true owner, but here Amit has right to recover the amount paid to Rajiv because implied condition related to passing of good title was not fulfilled. Second condition, sale by description as per section 15. When there is a contract of sale of goods by description, there is an implied condition that goods shall correspond with the description. Friends, we will see 2 circumstances over here. The first circumstance, buyer has not seen the goods and relies on their description given by the seller. So, say for example, a farmer described the quality of rice as basmati with long grain. Relying on the description provided by the farmer, buyer purchased 100 kgs of rice. Later, it was found that rice was of inferior quality. Can buyer reject the rice? Of course, he can, as the description did not match with the quality. The second circumstance, where buyer has seen the goods, but he relies not on what he has seen, but what was stated to him, and the deviation of the goods from the description is not apparent. For example, in an auction sale, certain pot sets were described as dating from the 17th century. The buyer bought the set after seeing it. Subsequently, he found that set belonged to 18th century. Can buyer reject the pots even after seeing, believing it, and if he purchased it? Yes, buyer has right to reject the set. To get the better clarity, let us have a look on another example. Asim visited an e-shop, selected and bought 2 shirts and paid for them through his credit card. He got the delivery 1 week later. The web page described that shirt is a pure cotton shirt, but the label inside the shirt mentioned 70% cotton, 30% polyester. Asim was of course unhappy and demanded that the shirt be taken back by the seller. Seller claimed that shirts were very popular and better than the pure cotton shirts. Do you think Asim should listen to the seller? Answer is, it is up to the buyer. As shirt did not match with the description, Asim has right to return it, but if he wish to, he can continue with the same shirt. The third condition, sell by description as well as by sample. This is the further extension of section 15. When sale is by sample as well as by description, it is not sufficient that the bulk of the goods corresponds with the sample if the goods do not also correspond with the description. It means goods shall correspond with both description and sample. For example, Aman agreed to sell to Gopal some oil described as refined oil, warranted only equal to sample. The goods tendered were equal to sample, but contained an admixture of hemp oil and not the pure refined oil. In this case, Do you think Gopal has right to reject the oil? In this situation, goods definitely match with the sample. But what about the description which was mentioned on the goods? Under such circumstances, if goods doesn't match with the description mentioned but match with the sample, still buyer has right to reject the goods. As implied condition is applicable for both samples and description. Now let us focus on the main part of these implied conditions. Condition number 4, condition as to quality or fitness as per section 16 subsection 1. Friends, normally in a contract of sale, there is no implied condition as to quality or fitness of the goods for a particular purpose. The buyer must examine the goods thoroughly before he buys them in order to satisfy himself that the goods will be suitable for the purpose for which he is buying them. However, some points need to be taken into consideration. First, where the buyer expressly or by implication makes known to the seller the particular purpose for which he needs the goods. Here, buyer depends upon the skills and judgment of the seller whose business is to supply goods of that description. There is an implied condition that the goods shall be reasonably fit for that purpose. For example, an order was placed for some lorries to be used for heavy traffic in a hilly area. The lorries supplied were unfit and broke down. This is a breach of condition for fitness. Second one, in case the goods can be used for number of purposes, the buyer must tell the seller the particular purpose for which he requires the goods. If he does not, he cannot hold the seller liable. For example, Ram bought a car thinking that it would be suitable for long tours. The car was uncomfortable and unsuitable for that purpose. The specific requirement of the touring purpose was not brought to the notice of the seller. In this situation, one cannot hold seller responsible because car was suitable for city drives but not for long tours. If Ram would have told the purpose, seller might have suggested some other car. The fifth condition, condition as to merchantability as per section 16 subsection 2. It is an implied condition that goods must be of a merchantable quality. As such, this concept is not defined in the Sale of Goods Act, but English Sale of Goods Act defines this term. Section 62 1A defines merchantable as goods of any kind are of a merchantable quality if they are as fit for the purpose for which goods of that kind are commonly bought. As it is reasonable to expect, having regard to any description, the price and all other relevant circumstances. If goods are of such a quality and in such a condition that a reasonable person acting reasonably would accept them after having examined them thoroughly, they are of merchantable quality. It means goods should be fit for the purpose for which they are used. Like a watch that will not keep time, a pen that will not write can't be regarded as merchantable under such names. We will see one example. A radio set was sold to a layman. The set was defective. It did not work in spite of repairs. It was held that buyer could return the set and claim the refund. Condition 6. Condition implied by custom as per section 16 subsection 3. In certain cases, the purpose for which goods are required may be ascertained from the acts and conduct of the parties to the sale or from the nature of description of the article purchased. If a bottle of milk is purchased, then the purpose for which it is purchased is implied in the thing itself. In such case, buyer need not tell the seller the purpose for which he buys the goods. For example, P asks for hot water bottle. the chemist supplies the one which burst after few days of use and P was injured. The chemist was held liable for breach of implied condition because P had made known to the chemist the purpose for which he required the bottle. The next condition, sale by sample as per section 17. A contract of sale is a contract for sale by sample where there is a term in the contract. Express or implied to that effect, in case of sale by sample, there is an implied condition. The first, that the bulk should correspond with the sample in quality. The second, that the buyer shall have a reasonable opportunity of comparing the bulk with the sample, and the third, that the goods shall be free from any defect, rendering them merchantable. We will see the famous case of James Drummond versus Van Ingen. A buyer, Van Ingen, had ordered the cloth as per the sample. The goods were to be of the same quality and weight as of the sample. Ingen delivered the cloth supplied to him by Drummond, but his customers returned the fabric stating it is not fit for stitching. The fabric tore under strain while stitching coats. The goods matched with the sample but did not fulfill the criteria of merchantability as fabric was defective. Thus, in this case, decision was given in favor of Ingen and Drummond was ordered to replace the entire consignment. Condition 8. Conditions as to wholesomeness. In case of eatables and provisions, in addition to merchantability, there is another implied condition that the goods shall be wholesome. Wholesomeness is related to the purity, that is free from adulteration. For example, Raj purchased milk. Milk contained water as well and was not in a pure form. He could recover the damages as goods were not wholesome. Or let us say if someone has purchased turmeric. If it is admixture of yellow powder along with the turmeric powder, then it means it does not fulfill the condition of wholesomeness. So, buyer has right to reject the goods purchased. I hope these points must have cleared your doubts related to conditions. So, friends, now let us have a look on the implied warranties. The warranty makes it clear that it is meant to limit the rights of the buyer. A warranty limits the liability of the seller. There are 4 implied warranties. Warranty number 1, warranty of quiet possession, section 14, subsection B. In a contract of sale, unless there is contrary intention, there is a possession of the goods. If the buyer is in any way disturbed in the enjoyment of the goods in consequences of the seller's defective title to sale, he can claim damages from the seller. Say for example, Akash purchased a plot of 1 acre from Ravi. Actually, that plot belonged to Amit, who was not aware of this contract of sale. When Akash started fencing around the area, Amit objected the same, stating that he is the true owner. Thus, Akash's right of enjoyment was disturbed due to the defective title of Ravi. Here, Akash can claim damages from Ravi for breach of warranty. Warranty number 2, warranty for freedom from encumbrances as per section 14, subsection C. In addition to the previous warranty, the buyer is entitled to a further warranty that the goods are not subject to any change or right in favor of the third party. If his possession is in any way disturbed by the reason of the existence of any charge or encumbrance on the goods in the favor of third party, he shall have a right to claim damages for breach of his warranty. Warranty number 3, warranty as to quality or fitness by usage of thread as per section 16, subsection 4. An implied warranty as to quality or fitness for a particular purpose may be annexed by the usage of thread. This is similar with the implied condition of quality and fitness. We will see more examples of the same at the end. And the last warranty, warranty to disclose the dangerous nature of the goods. Where a person sells goods knowing that goods are inherently dangerous or they are likely to be dangerous to the buyer and the buyer is ignorant of the danger, he must warn the buyer of the probable danger. Otherwise, he will be liable for damages. For example, A sold a tin of disinfectant powder to C. He knew that it was likely to be dangerous to C if it was opened without special care being taken. C opened a tin, whereupon the disinfectant powder flew into his eyes, causing injury. A was liable for damages to C as he should have warned C of a probable danger. Friends, now we will see the last part of the conditions and warranties, a doctrine of caveat emptor. It means let the buyer beware. In a contract of sale of goods, the seller is under no duty to reveal unflattering truths about the goods sold. Therefore, when a person buys goods, it is his responsibility that he must examine the goods thoroughly. If goods turn out to be defective or if do not suit the purpose, he cannot blame anybody except himself. Let us explore this in the light of an example. Minnie bought a packet of Lays from self-service store. After reaching home, she realized that it was not her favorite brand. The packet was also green and white in color and was a new brand. Minnie wants to return the packet and claim her money. Does she have a remedy? In this example, it was responsibility of Minnie to check the name of the brand, that is Lays. As it was a self-service store, seller was not aware about her expectations, nor did she inform him about her requirements. Thus, it was the responsibility of the buyer to check the brands and accordingly make the purchase. Doctrine of caveat emptor has three main exceptions, which are the first one, fitness for the buyer's purpose, second, mercantile quality, and the last one, consent by fraud. Friends, we have thus come to the end of this session. To summarize today's session, we studied conditions, warranties, implied conditions and warranties, express conditions and warranties, and finally, doctrine of caveat emptor, all in the context of Sale of Goods Act 1930. I hope you will make good of this knowledge when you join the corporate world. Thank you for your patient listening and have a great day ahead.